Imagine this, a really sophisticated scheme, almost like something from a movie. We're talking staged construction accidents, fake injuries, even unnecessary medical procedures. And all of it apparently designed just to generate fraudulent payouts. It sounds wild, but it's actually at the heart of a real-life federal lawsuit we're digging into today. We're taking a deep dive into the recent court decision in Roosevelt Road Re, LTD and Tradesman Program Managers, LLC v. Herbert S. Subin, Eric D. Subin, Jorge Arturo Gonzalez Lupi, and several others. This case involves allegations of, well, really massive fraud, something impacting the whole construction insurance industry right here in New York. So our mission today is twofold. First, let's unpack this alleged fraud, try to understand how it supposedly worked, and then, maybe more importantly, figure out why a federal court recently dismissed the lawsuit, especially those powerful RICO claims. That's the Racketeer Influenced and Corrupt Organizations Act. What does this specific ruling tell us about how the legal system defines injury, defines causation, especially in these super complex financial schemes? And why should that matter to you?
Absolutely. And just so you know, our insights today are coming straight from the source. The official Memorandum Order from the United States District Court, Eastern District of New York, on this very case.
Okay, let's get into it. The alleged scheme, we have the plaintiffs, Roosevelt Road Re, they're a reinsurer based in Bermuda and Tradesman Program Managers, a New York company. They act as a management general agency for insurers. And they accuse several individuals and a law firm of cooking up this huge fraud. So how did this whole thing allegedly work, sort of from the ground level?
Yeah, the alleged method is really something. The plaintiffs claimed you had these people called runners. Defendant Jorge Arturo Gonzalez Lupi was named as one. And these runners supposedly coordinated with attorneys, specifically Herbert S. Subin and Eric D. Subin from the Subin firm. The claim is they recruited construction workers specifically to stage fake accidents on job sites, fake falls, fake injuries. And then, of course, these workers would claim bodily injuries and, go seek medical treatment.
Okay, so the accident is staged. But the fraud didn't stop there, right? That was just step one. How did they allegedly turn these fake injuries into actual money?
Exactly. It kept going. The runners then allegedly referred these workers over to the Subin firm. The firm would then file lawsuits against companies involved in the construction projects, owners, contractors, whoever they could, and the Subin firm would naturally take a percentage of any judgment or settlement money. Standard practice, in a way, but based on alleged fraud here. But it went even further. The Subin firm also allegedly sent claimants to other law firms to handle workers' compensation claims. And, this seems crucial, they directed the claimants to very specific medical providers.
The medical angle.
Right. And these providers, supposedly in exchange for all these referrals, would then create false medical documents, reports, diagnoses, whatever it took to inflate the value of the claims. So the whole alleged goal was just generating cash through bogus judgments, inflated settlements, and workers' comp payments. A real alleged ecosystem of fraud.
And this wasn't like a one-off thing. The court documents, the amended complaint, they seem to suggest this was happening a lot. Widespread. Systematic, even.
That's definitely the picture painted. The court record mentions that since 2018, the Subin firm has been involved in literally thousands of lawsuits related to construction work. And often, these lawsuits were paired up with workers' comp claims, just like the alleged scheme describes. The court even gave a specific, though anonymized, example. They called him Claimant A. Lupi, the alleged runner, supposedly introduced Claimant A to Herbert Subin around December 2019. By March 2020, Claimant A was apparently referred to another law firm and a whole bunch of medical providers. The claim is this was for unnecessary tests, unnecessary treatment, even surgeries later that year in September 2020.
Wow.
And the defendants allegedly used, everything to coordinate this. Phone calls, texts, emails, regular mail. Things got interesting when a defendant in one of these underlying lawsuits actually tried to claim fraud against Claimant A. Soon after, the Subin firm moved to withdraw from representing him.
Telling. And it wasn't just these plaintiffs, tradesmen and Roosevelt, who were raising flags, was it?
No, exactly. The court order mentions that by late 2023, early 2024, a different reinsurer had complained directly to the Subin firm. They noted a significant increase in claims under New York's scaffold law. That's a big deal in construction cases here. And this other reinsurer pointed out that the highest number of suspected fraudulent cases seemed to be coming from the Subin firm.
That really paints a picture, doesn't it? The sheer alleged scale is kind of staggering.
It really is. And the plaintiffs here, Roosevelt and Tradesman, they claim they were directly hurt by all this. Roosevelt, being the reinsurer, said, look, we had to pay out on these bogus claims that the primary insurers covered. Plus, our costs for adjusting liability claims went way up. And tradesmen, their role was managing claims payments. They said they were processing these claims based on false documents, and they had to spend a lot on administration, even hire extra staff just for investigations.
Okay, so you've got this incredibly detailed, seemingly widespread alleged fraud. You have plaintiffs claiming direct financial harm. Why on earth would a federal court throw out the main claims? This is where it gets, well, really interesting legally.
Right. This brings us squarely to RICO, the Racketeer Influenced and Corrupt Organizations Act. Now, civil RICO, the part that lets private parties sue, it's a very powerful law. It allows people or companies injured by racketeering, by this kind of pattern of criminal activity, to sue for triple damages sometimes.
Ripple damages, yeah.
That's huge. It is. But to win a civil RICO case, you have to prove a few things. You need to show an injury caused by the defendants conducting some kind of enterprise through a pattern of this racketeering activity, like mail fraud or wire fraud, potentially. But the absolute linchpin here, the thing the court focused on almost entirely, is this requirement. You need a cognizable direct injury.
Direct injury, not just any injury.
Exactly. It can't just be an indirect consequence.
So it's not enough to just say, well, because they did all that bad stuff, eventually down the line we lost money. There has to be a tighter connection.
That's precisely it. The court honed in on what's called RICO's direct relationship requirement. Lawyers often call it proximate cause. It's not enough for the defendant's actions to be a but-for cause. But for what they did, we wouldn't be hurt. That's too broad for RICO.
Okay.
There must be a direct line between the injury, the plaintiff claims, and the specific illegal conduct the defendant engaged in. The Supreme Court has actually been very clear on this over the years. They've warned courts not to let RICO claims proceed if the injury is like several steps removed from the actual wrongdoing. You can't go well beyond the first step in the causal chain.
Can you give us an example of how the Supreme Court drew that line?
Sure. The district court relied heavily on these precedents. Take Anza v. Ideal Steel. There, a steel company sued its competitors. The competitors weren't charging sales tax rates, so they could offer lower prices and steal customers.
Okay, seems like the plaintiff was hurt.
They were hurt, yes. But the Supreme Court said the direct victim of the RICO violation, the failure to pay sales tax, was the state of New York, which lost tax revenue. The plaintiff's injury, losing customers due to lower prices, was seen as distinct and indirect result of the defendants defrauding the state, too remote for RIC.
Interesting. Okay, what else?
Then you have Hemi Group versus City of New York. New York City sued an out-of-state cigarette seller. This seller wasn't filing required reports about who they sold cigarettes to in New York. This meant the city couldn't figure out which residents bought cigarettes online and didn't pay city taxes on them. The Supreme Court said, again, far too indirect. The direct cause of the city's harm was the customers failing to pay their taxes. Hemi's failure to file reports was a step removed.
So the failure to report enabled the tax evasion, but wasn't the direct cause of the lost revenue itself.
Exactly. And one more, a really foundational case. Holmes versus SIPC. SIPC, the Securities Investor Protection Corporation, covers customer losses when brokerage firms fail. They sued some people for stock manipulation that allegedly caused broker-dealers to collapse. SIPC had to pay out claims to the customers of those failed brokers. The court rejected it. Too remote. SIPC's injury was totally dependent or contingent on the harm first suffered by the broker-dealers. It wasn't direct.
Okay, I think I'm getting it. This direct injury requirement under ICO is really, really strict. It's about who was the immediate target, the first domino to fall in a sense.
That's a good way to put it, the first step.
So applying this very strict standard, what did it mean for the plaintiffs in this case, in Tradesman v. Subin? Let's take Tradesman first. They argued they spend a lot of money managing and investigating these supposedly fake claims. Why wasn't that a direct injury?
Well, the court essentially agreed with the defendants on this point. It found tradesmen's alleged injuries just weren't directly caused by the defendant's alleged fraud scheme. By tradesmen's own description of its role, it wasn't the intended target of the fraud.
Right, you said the targets were the construction employers, maybe the workers' comp board?
Precisely. Tradesmen only got involved because it acts as an intermediary, a service provider, helping the insurers who covered those employers deal with the claims. The court pointed out that costs you incur investigating potential wrongdoing are usually seen as costs related to your own actions, your own business decisions, not a direct injury inflicted by the defendant's RICO violations.
The court used kind of a sharp analogy too, didn't it? about their business model.
It did, yeah. It was quite pointed. The court basically said, look, Tradesman is in the business of processing insurance claims, including investigating potentially dodgy ones. That's what they get paid to do. The analogy used was something like a mechanic complaining about the cost of buying windshield glass because kids are throwing rocks at cars. But then that same mechanic makes good money invoicing customers for replacing those broken windshields.
Ouch.
Yeah. The court noted tradesmen never actually claimed that the extra costs of investigating the alleged fraud exceeded the revenue they earned from handling those very same claims for the insurers.
So the court saw the costs as just part of doing business for tradesmen.
Essentially, yes. And the chain of causation was just too long, too indirect. Think about it. Alleged fake claims lead to lawsuits against construction employers. The employers contact their insurance companies. The insurance companies then hire tradesmen to manage and investigate the claims.
In several steps.
Exactly. The court found it too contingent, too indirect, very much like those Supreme Court cases we talked about, not direct enough for RICO.
Okay, so that's tradesmen. What about Roosevelt, the reinsurer? Their position seems even more removed from the initial alleged fake accident. Was their injury seen as even more indirect?
Oh, absolutely. The court found Roosevelt's alleged ICO injuries were, and I quote, too attenuated to survive dismissal, even more so than tradesmen's. As a reinsurer, Roosevelt's harm is, almost by definition, multiple steps away from the underlying alleged fraud.
Because they reimbursed the primary insurers who were the ones actually paying the initial claims?
Precisely. Roosevelt's obligation to pay only kicks in after the primary insurer pays. So their injury is derivative of an injury to a third party, that third party being the primary insurer. And the primary insurer's injury, in turn, is arguably derivative of the harm first suffered by the construction employer who was sued based on the fake claim.
This is like doubly indirect.
Doubly contingent, yeah. That makes it way too remote under that strict RICO proximate cause standard. Roosevelt also tried to argue it suffered direct injury from paying unnecessary legal fees related to all this, but the court shut that down too. It clarified that legal fees usually only count as a direct RICO injury if the plaintiff itself was the direct target of, say, frivolous lawsuits launched as part of the scheme.
Which wasn't Roosevelt. They weren't being sued directly.
Right. Roosevelt's legal costs were seen merely as a downstream consequence of the employers and the primary insurers having to deal with more litigation. Again, indirect.
So wrapping up the court's decision then. Despite this, as the court called it, picture of a troubling fraud,
Yes.
the plaintiffs just couldn't show that their specific injuries were a direct result of the defendant's alleged racketeering activities as required by RICO.
That's the heart of it. The court concluded they failed to plead cognizable direct injuries under RICO. And that failure was, in the court's words, the first and foremost reason for dismissing both the main RICO claim and the related RICO conspiracy claim. Because the federal RICO claims were dismissed, the court also chose not to keep the related state law claims, things like common law fraud and unjust enrichment. It dismissed those without prejudice.
Without prejudice meaning they could try again somewhere else.
Exactly. It means those specific state law claims weren't decided on their merits in federal court, and the plaintiffs could potentially refile them in New York state court, which might have different rules about causation or standing.
But the federal case, the RICO case, isn't completely dead in the water just yet, is it? There's a chance for another try.
That's right. The court, showing perhaps what it called an abundance of caution, did grant the plaintiffs leave to amend their complaint. They have until July 21, 2025, to file a new amended complaint. This gives them one more shot to try and plead facts differently, to maybe argue for a more direct link between the alleged fraud and their injuries, specifically addressing the court's concerns.
So the legal battle could continue.
It could. The case is technically still active, though discovery the evidence gathering phase is paused until the plaintiffs decide whether and how to amend their complaint. It'll be really interesting to see if they can reframe their case to meet that very high RICO bar.
Okay, so let's zoom out. What does this whole deep dive into Tradesman v. Subin really tell us? For me, it's a really stark reminder. Even when you have allegations of truly massive, widespread fraud, the specific legal tools you choose to use, like civil RICO, have incredibly strict, very specific requirements.
That's absolutely right, and it raises a critical question for you to think about. This case perfectly highlights just how tough those legal hurdles are for civil RICO, especially proving that direct causation. It really shows how complex business structures, like the layers of insurance and reinsurance we saw here, can make it incredibly difficult to prove direct harm in court, even when there's smoke suggesting widespread wrongdoing. It might leave some parties who feel genuinely harmed without the powerful federal remedy RICO offers.
And that leads to a final thought for you, our listener. What does a decision like this mean for companies or even individuals when they're trying to figure out the best legal path forward after being harmed by some complex scheme? Does this ruling push potential plaintiffs to focus only on suing the most immediate wrongdoer, the first step victim? Or does it risk leaving significant but indirect financial harm without any real recourse in federal court? Is that fair? Is that how the law should work? Definitely something to mull over. We'll certainly keep an eye on how this case develops.